Well, the Supreme Court has been asked to weigh in on the illegality or legality of the appointment of Matthew Whitaker as acting Attorney General. So what could they decide if they take it? Hans von Spakovsky joins us, senior legal fellow at the Heritage Foundation and former Justice Department official. Hans, always good to see you. First start, do you think that the appointment of Matthew Whitaker is legal?
Yeah, it is. The critics of this have a couple of problems. First of all, these kind of temporary appointments have been made since George Washington. So we have over 200 years of these practices. Second, the president acted fully in compliance with the Federal Vacancies Reform Act, a law that's been used, for example, by Barack Obama to make similar appointments. And the Office of Legal Counsel at the Justice Department issued its third opinion this past week of the Justice Department on this issue, saying this is perfectly constitutional. And by the way, they pointed to an 1898 U.S. Supreme Court decision called U.S. v. Eaton that approved these kind of temporary appointments.
Well, you know what the legal critics say in their filings. Thomas Goldstein, who's really a Supreme Court expert, he founded this SCOTUS blog, as you know. Here's what he wrote in one of his filings in the suit going to the courts. As long as there's been a Department of Justice, Congress has mandated that only a Senate-confirmed official can serve as acting Attorney General. Those provisions are mandatory. The president cannot designate anyone else because Whitaker's appointment does not satisfy the Appointments Clause. It is unlawful, and he cannot serve as acting Attorney General. I mean, they say, look, the guy's not confirmed by the Senate, so it's illegal.
Yeah, but what Goldstein says in that pleading is not correct. The Federal Vacancies Reform Act, in fact, allows this to be done, and what he is saying, what Goldstein is saying should happen would cause unbelievable chaos. And I'll just give you one example of this. As you know, when a president leaves office, all three of the 93 U.S. attorneys also leave. Those are Senate-confirmed positions. If an assistant can't be temporarily appointed to take over that job, all criminal prosecutions across the country by the U.S. Justice Department would have to cease and stop until the Senate confirms a replacement in each of those 93 seats. That would cause unbelievable chaos, and I just don't think the court is going to believe that that's a good result or one that was contemplated under the Constitution.
Only about 30 seconds left. You think the Supreme Court will take this? And if they do, how will they vote? I mean, Justice Kavanaugh would be a key?
Yeah, I think he is. Now, I think Clarence Thomas has expressed doubts about the constitutionality of this federal law that the president acted under, but I don't know how many other justices would have the same view. Like I said, it's very interesting that President Barack Obama used this same statute to make appointments in the same way, and no one questioned the constitutionality of that.
All right, we'll see what the Supreme Court does, if indeed they take it, and what the ruling could be. Hans von Spakovsky. Hans, always good to see you. Thank you.
Thanks for having me.
Of course.